All right, welcome everybody. It's the first Tuesday of the month, and that means that we are always privileged to have our good friend Rob Natelson from the Independence Institute, Senior Fellow in Constitutional Jurisprudence at the Independence Institute and the Montana Policy Institute. So, Rob, good morning, sir.
Good morning there, Peter. How are you?
Fantastic. It's a beautiful sunny day, a little crisp and cool. How are things in Denver?
Overcast, cool, and I'm told going to get a lot cooler.
Yeah, okay.
We're expecting frigid weather with snow later today.
Oh, well.
Well, Rob, I understand you've got a lot of stuff published. Big news for you coming out today. Tell us a little bit about what you got working on, and then let's go into a little bit of the article on freedom of the press you had sent us.
Sure. First, one item of good news. Picked up a citation at the Supreme Court again. This one involved the Arizona case, which is disputing whether the voters can delegate the allocation of congressional districts to an independent body, as they do in Arizona, as they also do in Montana. And one of the sides, specifically the commission itself, which is defending its own existence, cited an article I had written. So we'll see if a citation from one of the justices comes out from that. And then an article today in the American Thinker, which is an influential conservative or perhaps neoconservative website, announcing another article that I've written, which deals with issues of campaign disclosure. So it's a really happy morning for me.
Well, that campaign disclosure one is going to be interesting, I think, for the audience here in Missoula. You know, campaign finance disclosure is something that I actually just heard the governor speaking about here in Missoula a week ago. It's something that campaigns are fueled by here in the state, and not just the money that's pouring in, but just the messaging of disclosure. And I wanted to talk to you a little bit about, you know, the elements of freedom of the press and whether or not disclosure is tied to our Constitution's freedom of the press.
You know, it's an excellent topic. It's the one I investigated in the article that just came out, and it's you can find it on our website at constitution.i2i.org. That's constitution. The letter I, the number 2, the letter I, another .org. And the question I investigated is whether you have a right under the First Amendment to keep your name anonymous if you are contributing to an issues campaign. This issue arose in the Citizens United case. One of the holdings in that case has been widely attacked, but there's another holding that nobody pays any attention to, and in that one, the Supreme Court said that Congress can force the disclosure of the names of people who contribute to issue campaigns. That's a very popular issue. I think most people like disclosure. They like it because they like to know who's giving money to a campaign and, you know, what axes they might grind. On the other hand, it's also been recognized that forcing somebody to disclose his name in order to exercise his First Amendment rights can have the effect sometimes of shutting up people who want to exercise their First Amendment rights. Because people who get their names in public disclosure documents, you know, often find, as I did when I was active in Montana politics, that their mail has been tampered at, stuff has been thrown at the window of their house, there have been other acts of vandalism, there are sometimes threats of death or serious harm against you or your family. And so many people would rather contribute without, in fact, being disclosed. And so there are important values on both sides here, and my job was to look at the First Amendment and its history and figure out what side the founders would have come down on when they drafted the First Amendment.
So were you able to come to a clear conclusion, or is it murky?
It's not murky. It's pretty clear. It's not the clearest I've ever arrived at, but so it's not 99% clear, but it's 89% clear. There are two steps in this. Number one, when somebody contributes to an issues campaign, you know, folks are making a movie, a documentary, or they're putting an ad in the newspaper, or they're putting out flyers, that would have been deemed by the founders as an exercise of freedom of the press. Now that's important because the U.S. Supreme Court traditionally has talked about campaign speech as being freedom of speech. But actually the founders would have said, look, if you're not just, standing on a street corner orating, if instead what you're doing is you're using different media like pamphlets or newspapers or today the internet or movies, that's really freedom of the press, as the founders would have understood it. So that was the first thing that came to me as kind of an insight that I hadn't seen before. The second thing followed from that, and that was that the founders recognized the right to contribute anonymously as a core part of freedom of the press. The Federalist Papers are the most famous example. When Hamilton, Madison, and Jay wrote the Federalist Papers, they didn't sign their own names. They signed the Roman name Publius, which loosely means friend of the people. And most everybody else who invade in on the Constitution, whether for it or against it, wrote under a pseudonym, or they were simply anonymous if they were putting their thoughts in written form. And that was true not just of the writings on the Constitution. It was true throughout the founding era, both in America and Britain. People customarily offered their thoughts for public consideration without adding their names. And furthermore, and I'll finish up with this, I found multiple statements in the founding era literature in which they talked about privacy or anonymity or writing under a pseudonym as a part of freedom of the press. Forcing somebody to disclose someone's name without his consent was generally, not always, but generally considered a violation of freedom of the press.
Okay, now, Rob, allow me to jump in here and ask a quick question. What I hear you saying is that someone who is presenting political speech or writing political speech is perfectly, it's okay for them to use a pseudonym. But I think what a lot of the people are more concerned about is people who contribute to a campaign, who are not really speaking, they're not really taking a position, but they're giving money. Why should they also have that same right to remain anonymous?
Because money is part of speech, or part, in this case, of freedom of the press. You couldn't have a newspaper without an investment of money. I mean, if you took the position that the investment of money was not protected by freedom of the press, then the government could simply destroy any newspaper in the country by passing a law against contributing to it, or by severely limiting the amount of the contribution. Similarly, you could limit somebody to just speaking on the street corner by saying, hey, you can't spend money on an internet ad, or a magazine ad, or a radio, or a television ad, or a documentary, or a pamphlet. I mean, in fact, that in some ways is what distinguishes freedom of the press from freedom of speech, at least as the founders would have said it. Freedom of the press, you can stand up and, freedom of speech, you can stand up and talk without necessarily requiring money to do so. But in the case of freedom of the press, there is always an investment of money. And just as a newspaper owner is protected, a newspaper editor is protected, so also are the writers protected and the contributors. That's really pretty clear understanding from when you read over the founding era discussions of freedom of the press.
All right, well, we got to go to a break here in a second, but when we get back, if it's so clear, if it's so obvious, if it's 85% clear, as Rob said, then how do we get decisions like Buckley v. Vallejo? And how do we get other campaign finance decisions which seem to just have totally forgotten any element of the ability to hide your identity in the freedom of the press?
Okay, we're going to come right back, and we have two lines open. If you'd like to discuss this issue with Rob, give us a call. 721-1290 is our number. We're coming right back. Thanks for joining us on this Tuesday edition of Talkback. The first Tuesday of the month means it's Rob Natelson, who is the Senior Fellow in Constitutional Jurisprudence at the Independence Institute. Now, John, you just asked a question going into the break.
Well, yeah, Rob was saying that it's pretty clear. The evidence is that the freedom of the press allows you to write, in obscurity, to write without publishing your name. But if that's the case, then why does the Supreme Court over and over again seem to not get that point?
I think because it had not been thoroughly investigated. Justice Thomas dissented from that part of the Citizens United case, for example, that required people to turn their names over to the government. And he had, in an earlier case, explained, at least in part, what the founders thought about freedom of the press. But nobody, as far as I could tell, had really gotten deeply into it. One law professor who's gotten, a liberal law professor who's gotten public notice recently because he's been critical of President Obama, Jonathan Turley of George Washington University, he had suggested that author privacy might be protected by the First Amendment. But for the most part, people had not really investigated it. That's one of the reasons I undertook this project. It's one of the ways I operate. I go into an area that has not been thoroughly investigated or thoroughly written about and try to unfold it and explain it. And that's really what I did here. As far as I know, mine is the first pretty complete treatment of the subject. I won't say absolutely complete because who knows what others can find. But I think it's pretty complete, and I think it's pretty clear that as far as the founders were concerned, they believed that authors, contributors, were entitled to their privacy, except in a few narrow circumstances.
Oh, it's pretty clear that anonymity was pretty common, especially when it comes to a lot of the documents pro and against the Constitution.
It wasn't just common; it was the overwhelming custom. In my article, I go through several different collections of founding era documents, and in any 50, you might find one that was signed. In other words, if you look at 50 letters to the editor or pamphlets, you might find one that was signed by the true name of the author. Almost everybody either wrote anonymously or under a name like Publius or a friend of the people or Cato or Caesar or some other pseudonym, usually taken from classical Greek or Roman literature.
I hope the guy writing under the name of Caesar was doing it ironically, but
actually, we think the guy writing under Caesar might have been Alexander Hamilton, and in this instance, he was advocating for a very powerful federal government, and so I think it was probably an appropriate selection.
Fair enough. Well, okay, so I get your point that in practice, these men were writing under pseudonyms, but does that mean that it's actually case law? Is there anything in the law to back up your point?
That's one of the inquiries I went into. After looking at how often they wrote anonymously, I then asked, well, was that just a custom, or was that actually deemed to be a right that people had under freedom of the press? And the answer is it was very much considered to be a right. And I quote a number of authors here, both from England and the United States. There's also a very interesting story that arose out of Philadelphia. A man had written an article to the newspaper that was critical of Pennsylvania state government. This is in 1782. He's very critical of Pennsylvania state government, and his name was disclosed by the printer to the governor of the state. Well, the printer was just roundly criticized for this. How could you consistently, with freedom of the press, disclose this man's name to the governor? And so the printer wrote a lengthy defense in which he said, look, what happened here is the man didn't sign his name. The governor asked me if I could reveal the name if I had been given permission by the author to reveal the name. I said, well, I'd have to check. I called the author, and the author said, sure, you may reveal my name to His Excellency the Governor. And so only then, said the printer, did I actually reveal the name to the governor. Now, it's a very revealing story because it shows that the default rule, the rule that was always assumed, was that if you wrote under a pseudonym, the printer did not have authority to release your name to the government. And even the suggestion that a printer had voluntarily released the name to the governor, to the government, or to the governor, was viewed to be a violation of freedom of the press. Now, you can imagine how those folks would have looked at a situation today, where political committees or printers or movie producers or whatever have to list all the names of the contributors routinely handed over to the government to public disclosure. I mean, irrespective of whether that's a good idea or a bad idea as a matter of policy, I think the founders would have been horrified to think of that. They would have viewed it as a complete violation of freedom of the press.
You know, Rob, we're coming up against a break, but I want you to consider, if you would, these two questions. First of all, were you commissioned to study this subject, or is it something you did on your own? And what the repercussions of that might be. And I'm also wondering, once you now that you have published your results, what do you expect will happen? I mean, because it looks like what happened with the originators of the Constitution, the authors of the Constitution, and the Founding Fathers goes directly against the flow that is happening right now. And I'm wondering, do you expect your research to try to back that flow up? And we'll come back with more with Rob Natelson here in just a moment. We're back on Talkback. 721-1290 is our number, 1-800-568-5309. Rob Natelson joining us. And what I'd like to do, Rob, because this is a shorter segment, I want to save my questions till after the top of the hour break, so we'll have more time for Mike to get his opinion in here. And Mike, do you have a question for Rob?
Hi, Mike.
Yeah, I was just wondering if it could be argued that the tradition of pseudonyms at the beginning of our founding could be attributed to it was a lot higher stakes then. If you didn't use a pseudonym, the British could come into your house and take you out to the next tree and hang you for treason against the king. And I'm just wondering if that was a way to protect yourself from the British, and then it just carried on over once the Constitution was in the works.
It's a great question, and the short answer is no. There's a tradition of pseudonyms actually arose in Britain, and it arose way back in the early, at least as far back as the 1720s, maybe earlier. Also, on two occasions when I was discussing the issue, I said almost always author privacy was protected. But I noticed I did not say always. There were cases in which the government or even a private party could force the disclosure of an author's name. And one of those was if the writing was treasonous. So if the writing was treasonous, the authorities could always issue a subpoena on the printer and force the printer to reveal the author's name. Similarly, if the writing was arguably seditious or libelous.
The writing was
so there were exceptions there.
I'm sorry, go ahead, Mike.
Oh, I was just going to say, that's probably why the writing was so eloquent and didn't really come straight out, and it kind of beat around the bush quite a bit.
Well, there was a tradition of respect. It was called subordination, which wasn't quite as dirty a word then as it is now, but what it basically meant was that you treat the issues and you treat your opponents with respect. And if you went too far, then you were subject to the libel law.
Right.
So that's one reason why the writing there tends to be somewhat higher toned than the political writing you see today.
I see. Thank you.
Thanks, Mike. Thanks for the call. Now, with the minute and a half we have left, the questions I asked you, first of all, were you commissioned to do this article? And secondly, what do you believe will be the repercussions of your findings?
The answer is no, I was not commissioned to do the article. I was not paid for the article. I certainly was not paid for a particular conclusion. I have a very strict rule, and I think this is important for your listeners to know. I do not accept money that is contingent on reaching a particular conclusion. And I have repeatedly turned down offers to write in order to cherry-pick the evidence and try to reach a particular conclusion. So this was honestly reached. As to what the impact will be, I don't know. I mean, it's very possible that Justice Thomas, for example, who has long had some doubts about forced disclosure, will pick it up and, as he has done some of my other things, and publicize it that way. Certainly, it being the first comprehensive study of its time, of its kind, there's a possibility of that happening.
Great. And I hate to do this to you. We're right up against our hard break. We'll come right back. We have another hour with Rob Natelson, so stay with us. Hey, we're back on Talkback Now. John King, our show producer. I'm Peter Christian, joining us on the phone from the Independence Institute, the Senior Fellow in Constitutional Jurisprudence, Rob Natelson, former professor at the University of Montana. Now, Rob, before we get to Jeannie's calls, been waiting very patiently, you wanted to state a few more things about what the founders had to say about privacy, if you would.
Well, people might wonder why they thought it was so important that as part of freedom of the press, people had a right to remain anonymous. And that is basically to protect people from retaliation, and also to enable people to offer their thoughts on their own merits without readers simply saying, that's simply Joe, and dismissing it because it happened to be Joe raising the argument. Let me illustrate this by a very quick story. When I was running for governor in 2000, and I have this on reliable authority, when I was running for governor in 2000, a businessman had put a Natelson for governor sign up in his on his property. And one day, the superintendent of schools for one of the local school districts, who very strongly opposed my candidacy, came by and asked somebody, who is it that put up that sign? And he was told who put up the sign, and the school district superintendent's response was, well, he does business with the school district. He won't be doing business with the school district anymore.
Wow.
So this kind of petty retaliation happens. It happens in Montana, and it happens when people are forced to reveal their names. Justice Thomas, in arguing against disclosure, explains what happens to those people who contributed to Proposition 8 in California, which was a one-man, one-woman marriage proposal that passed in California. Those folks went through living hell as a result of retaliation simply because they'd made in some cases, small contributions to the campain.
Yeah, most notably
the founders were very aware of the need of the values behind protecting voter privacy, right of privacy. And I recognize their values on the other side, too. I'm just saying what the founders thought.
Yeah, I was going to say most notably with I think it was the CEO of Firefox got in big trouble with that.
Yeah, that's right.
Prop 8 donations and his name being on the list.
He gave a contribution to the Proposition 8 campaign, and reports are that he was forced to resign as the CEO. So the idea here is that people should be permitted to exercise their First Amendment rights, to contribute to the public debate without opening themselves to that sort of thing. And in some cases, by the way, the Supreme Court has recognized that. There's a very famous case, 1958, in which the state of Alabama tried to force the National Association for the Advancement of Colored People, the NAACP, to reveal the names of all their donors. The state of Alabama at that time was controlled by segregationists, and of course there would have been retaliation against donors to the NAACP. The Supreme Court said that chills free expression, we're not going to permit it. But in the part of the Citizens United case that you never hear about, the Supreme Court took the other tact and said, we'll force people to reveal their names.
Wow. Okay, let's get to the phone and say, first of all, Jeannie, thank you for your patience. Go ahead.
You're welcome. In regard to anonymity and privacy and the modern age, what would Rob think of people who write anonymously in the comment sections of newspapers and online forums? And I'll hang up and listen for the answer.
Okay, thank you, Jeannie.
What would I think about them? I think that entirely depends on what they're saying, how they present themselves, and what the issue is. That's different from what I'm discussing, which is the constitutional issue here. Do I believe they have a constitutional right to offer their comments anonymously so long as those comments are not libelous or slanderous or treasonous? Yeah, constitutionally, I think they absolutely do. But in many cases, I think it is more appropriate for someone to reveal his name. For example, if somebody is going to make a bunch of personal charges against another individual, accuse the guy, let's say, of cheating on his wife or messing with his sister, then I think that somebody who makes that kind of charge should be an adult, a man or a woman, and stand up and identify his or her identity. But if the comment is truthful, the person does have a constitutional right, in my view, of my reading of freedom of the press, to keep the comment anonymous, even though I think it is not in good moral character to do so.
I'd like to stick with the topic just a little bit more because I find it fascinating, and it's something that we are going to hear over and over in Montana's campaign cycles. And it just seems to me that there is a difficulty I have with the transcribing of the idea of freedom of the press in the 1700s to what we have now available to us as forms of media. How confident are you in saying that an internet ad or a radio ad is of the same character and tenor as a newspaper article would have been back then?
Well, do you remember I said that unlike some of my other studies, which leave me 99% certain, this one left me more like 89% certain, and that accounts for most of the uncertainty. Can you take the 18th century press environment and transfer it to today's media? I think you can, but I also think you can argue about it. For example, freedom of the press included the right to write a letter to the editor, during the founding era. Well, we have letters to the editor today. And many newspapers insist that they be signed, but actually the mores of the founding era were that you permitted somebody to write a newspaper letter without signing it. What about leafleting? Well, we do that today. We do that in the founding era. That's also fits well with freedom of the press. What about pamphlets? Well, we have pamphlets today. We had them at the founding era. Well, what about movie documentaries like the movie about Hillary Clinton that the Citizens United Corporation made? Well, a documentary is almost exactly an electronic version of an 18th century pamphlet. It's an electronic medium rather than a printed medium, but it's pretty much the same in the same way that a personal letter is the same whether you send it by the post office or whether you send it by email. Well, what about other internet communications, or how about this communication we're doing right now over the radio? Is that freedom of the press, freedom of speech, or something else? I think if you were to ask James Madison or John Dickinson, they would say it's freedom of the press. Rob Natelson right now is speaking through an independent medium to an audience. His voice is amplified, perhaps to the chagrin of many. His voice is amplified far beyond what it would be if I were merely speaking on a street corner. That's freedom of the press. And so you can argue somewhat about those analogies, but I think they're pretty sound. And by the way, the Supreme Court makes those kinds of analogies all the time. The Supreme Court, for example, in dealing with the search and seizure rules of the Fourth Amendment, has to deal with things like thermal imaging and X-rays that didn't exist in the founding era. But they do deal with those things, and they deal with them fairly successfully. Yeah,
Rob, we're up against a break, but I wanted to ask you a question about a letter to the editor. Let's say that an individual wrote a letter to the editor, and it was rather not necessarily inflammatory, but it would cause a great deal of controversy, and say, look, I would like to post this on your newspaper anonymously, but I'm going to give you my name and address just in case there's any legal problems. Is that something that would be acceptable, do you think?
At the time of the founding, that was up to the printer. The printer could insist upon the name of the contributor, and it was probably wise for the printer to do so if the article might possibly be construed as libelous or violate the law in other ways. So that was probably good practice. On the other hand, as the anecdote I told a few minutes ago illustrated, it would have been considered an outrageous breach of freedom of the press for the printer to reveal the name to the government or to anyone else.
Okay, and
unless there was a legal proceeding involved.
Okay, we're going to come right back. Catherine, we'll get you on in a moment. We have one line open. Rob Natelson, our guest, Senior Fellow in Constitutional Jurisprudence from the Independence Institute. We'll be right back. All right, we're back on Talkback 721-1290. Rob Natelson joining us from the Independence Institute, and waiting very patiently on the phone is our friend Catherine. Hi, Catherine. Go ahead.
Good morning. Morning,
Hi,
Rob.
Catherine.
Okay. Freedom of the Internet equates to freedom of the press. However, the backbone of the Internet was created originally by the government for the military, and the feds control ICANN, which is, of course, the backbone of the network. Businesses figured out how to create private business off the internet. And the FEC, which is now in the process of asserting control or talking about asserting control, figuring out rules and regulations, the public doesn't know exactly what they're going to do, but they seem to be wanting to assert some form of control of content. The larger companies like Google have announced they will start rating websites by fact, not volume of traffic, and that depends, of course, on who is fact-checking. They've also announced that they're looking to expand wireless content, and I'm wondering where the FEC and their authority lies in all of that. Do they have the right or duty to do that unilaterally, or does the Fed have control of the air itself and the sound waves therein? And also, does the Fed assertion of control, shouldn't Congress be the one to at least pass legislation to do that?
Okay, well, Catherine, let me start with a caveat here, the warning. I'm not a federal communications lawyer, so accept what I'm going to say with that in mind. Number one, the FCC has, in fact, issued those rules. They issued them the other day.
Okay.
And what they do is they impose requirements on Internet service providers that Internet service providers can't block certain content. Internet service providers can't provide higher speeds for higher prices. They are kind of public utility type regulations. The authority for the FCC comes from a law passed in the 1930s, which
the phone laws,
was designed really for radio, I think. At that time, while the thinking was you could have an infinite number of newspapers, the number of radio bands was limited to a fairly small spectrum, and therefore radio should be treated as a public utility. But we recognize now, as a result of technological change, that particular reasoning was faulty, and generally there's been a move toward freeing up radio stations from those kinds of public service type regulations. For example, the repeal of the Fairness Doctrine. I personally think the law that authorizes the FCC to do this sort of thing is unconstitutional. I think it's a violation of freedom of the press for the reasons we've been discussing today. But I'm not the Supreme Court, and the Supreme Court is going to have to deal with this. I think the 1930 rationale for the FCC regulating the Internet, or for that matter, regulating radio the way they do, is long out of date, and really needs to be swept away. Let the free market of ideas bloom, and get the government out of it. That's my view.
Catherine, next question.
Well, I was going to just mention that a lot of the old rules have to do with a hard network, not a wireless network. And so, is there a workaround, do you think, by going totally wireless? Because how do you control sound waves, or how does the government assert control over sound waves that do not travel through a fiber optic network?
Yeah, I don't frankly think there's a constitutional difference. I don't understand why there should be a constitutional difference, but I'll leave that to the communication lawyers to deal with.
Thanks, Catherine.
Maybe you can get one on.
Yeah, well, we're going to, as a matter of fact, we were going to try to get somebody on to talk about that, and we did just the other day, in fact.
Yes, if Peter remembers, it was just 24 hours ago.
I'm sorry!
That we were talking about that topic.
Yes, that's because I didn't understand a word he said. But
the guy said internet, and Peter just fell asleep.
Yeah. What's the internets anyway? So we're going to come right back. We've got more with Rob Natelson. 2 lines open, by the way. 721-1290 is our number, or 1-800-568-5309. Stay with us. More coming up. Hey, thanks for joining us on Talkback. John King, show producer. I'm Peter Christian, the co-host, and joining us on the show, of course, Rob Natelson, first Tuesday of the month.
Okay, I wanted to shift gears. Down in Arizona, the Supreme Court is dealing with an issue that is a similar experience to what we have here in the state of Montana. Basically, my understanding is and maybe Rob can correct me. There's a panel of 5 people that reapportion the districts for voting in the state, and this is for congressional districts or for your Senate campaigns, those sorts of things. People that we're going to be sending to D.C., in other words, to vote on various pieces of legislation. Now, every year when people look at these districts all over the country, you notice, if you look at some states, you've got these squiggly lines. It looks like a 6-year-old was trying to draw a snake. And it's a process well known as gerrymandering, where districts kind of, cut up what might be, let's say, a Democrat block of the city and just piecemeal it into other larger Republican areas so that you dilute the vote of one party against the other. I was just using the Democrats in this case as an example. It's, of course, happened to Republicans as well. Anyway, one of the ways that states have come up with trying to combat this was to have a panel, instead of having the legislature itself do it based on majority vote, having a panel do it with 2 members of each party represented and then a 5th member to kind of break ties. And the idea behind this is that it's going to prevent gerrymandering. Anyway, this lawsuit in Arizona is arguing, my understanding is anyway, that these types of committees are unconstitutional. And apparently, Rob, one of your articles is being cited in this case. Tell us a little bit about your involvement with it.
I've not been involved with the case at all. My article got cited because, remember, I was talking about how earlier when I looked for areas that have not been written much about, and that was the case. There's a provision in the Constitution that they're now battling over that had never been the subject of a competent treatment of its historical development and its meaning. And so in 2010, I wrote an article on this particular provision in the Constitution. It was picked up in a case last year by Justice Thomas, who cited it in one of his opinions. And now one of the parties to this case is citing it. Look, here's what the case is about. The U.S. Constitution gives to the state legislature the initial power to divide a state into districts for electing congressmen. Now, we're talking congressmen here. This has nothing to do with state legislators. And in Montana, of course, you only have 1 congressman, and so this is not an issue right now. But if you've got a second congressman, this could become an issue. Under the Montana Constitution, this independent reapportionment commission would be in the business of dividing the state into congressional districts, as happened in the past. Okay, so is that constitutional? Is it constitutional to use a commission when the Constitution says it's the power of the legislature to do this? Now, it's long been recognized that the term legislature in the Constitution can have two different meanings. Sometimes it means the legislative authority of the state, whether that legislative authority be exercised by a commission or by voter referendum or anything else. In other parts of the Constitution, the term legislature means the specific body that meets in the state capitol, the representative body, and it alone, not counting the governor's veto, not counting initiative referendum. So the term is used in both ways in the Constitution. In Article 5, the amendment article, which we've talked about, it's well established it means only the legislature as an independent body. But the Supreme Court had previously said that when you're determining how to break the state into congressional districts, the legislature means the entire legislative power of the state. And so this is a lawsuit between the commission and the Arizona legislature. And the Arizona legislature is saying, hey, look, when the voters gave you, the commission, the power to divide Arizona into congressional districts, they violated the Constitution. That power belongs to us, the legislature, and nobody else. And so that's what the fight's about.
I want to read, this is from a Wall Street Journal article called The Constitution and the Gerrymander. And this article brings up some of the back and forth between the Supreme Court justices and the lawyers representing the defense in this case, I believe. Anyway, the question was asked, and they're talking about this issue of what legislature means. What is. Anyway, so the Justice Samuel Alito, and I'm quoting here from the piece here, as Justice Samuel Alito asked Seth Waxman, the lawyer representing the Redistricting Commission, quote, is there any other provision where the legislature means anything other than the conventional meaning? And I think what Alito is referring to as the conventional meaning being that of the legislative body of the state legislature.
Like ours is in session now.
Exactly.
Okay.
If you were to get the same question that this attorney did, which apparently the attorney didn't have an answer, what would your response be, Rob?
My response would be, yeah, there is. In Article 2, it provides that electors, presidential electors, are chosen in such manner as the state legislature shall determine. And that's always been understood that the state legislature passes a law which is then subject to the governor either vetoing it or signing it. In other words, the legislative power of the state. So, and there are two Supreme Court cases out there. They're kind of old, but there are two Supreme Court cases which seem to say that when the term legislature is used in the elections clause, it means the legislative authority of the state. So the Arizona legislature bringing this lawsuit has got to find a way to get the Supreme Court not to follow those earlier cases. But it's absolutely certain that there are other parts of the Constitution where legislature just means the individual body, not as a branch of state government, but the individual body. And one example of that is the guarantee clause of Article 4. Another example of that is Article 5, the amendment process.
I hope when Montana gets another representative, we decide to apportion by groundhog, and that whenever if the groundhog pops out of the hole, wherever he looks, that half of the state is going to be one district, the other half.
I like it.
And we could be the butt end over here or whatever. Who knows?
Now, Rob, on a semi-serious note, what this article is talking about is state redistricting. But here in Missoula, there have been charges over the last several years that when they redistrict city council areas or wards, as we call them, there have been claims by some that it's been gerrymandered in that respect. Would that decision also apply to a municipal type situation, such as here in Missoula?
No, it applies only to members of Congress. This deals with a particular part of the Constitution. It's Article 1, Section 4, Clause 1, that is called the Time, Manner, and Places Clause or the Elections Clause. And it specifically refers to the dividing up of a state. It talks about the places of elections, which includes, but is not limited to, the dividing up of a state into congressional districts. So they're talking about Congress only.
Gotcha.
So if this opinion goes in favor of the state legislature down in Arizona, the effect in Montana, there won't be an immediate effect in Montana because Montana is not divided into congressional districts. But as soon as Montana gets a second congressman, then it will have an effect in Montana because that will mean that only the legislature, not the commission, can draw the districts.
Perfect. All right.
I'm not sure, frankly. There's another aspect of this case I want to mention. It's a real Republican-Democrat type thing because you got a Republican legislature. See, the Republicans control most legislatures at the state level around the country, and then you got this independent commission, and they very often are controlled by Democrats. And so there's sort of this partisan thing. I may surprise you and tell you I think the Democratic Commission probably has the better constitutional argument than the Republican legislature has. That's my first impression of this case.
Okay, we're going to take a break. Patty is being very patient. We'll get to her in just a moment. And we have one line open if you'd like to visit with Rob Natelson. We're coming right back. Hey, it's the Tuesday edition of Talkback. 721-1290 is the number. John King over there. I'm Peter Christian. Rob Natelson joining us from Denver, Colorado with the Independence Institute, where he is the senior fellow in constitutional jurisprudence. Now, we have a caller on the line. Jim, you are on with Rob Natelson. Please go ahead, sir.
Hi, Jim.
Well, good morning, Rob.
How are you?
I am busier than a feather merchant in a tornado.
Okay.
I appreciate what you're doing. Have you heard of a book called Uncle Eric book series, Whatever Happened to Justice?
I have not.
Well, you might want to get that book because it's got little letters to a son or somebody that he writes, but he has definitions in there that I thought were very interesting. And one of them is on, in the glossary in the back of the book, he talks about legislation. made law as distinct from discovered law. And then further on down the page, it talks about politics. And the word politics, maneuvering to acquire use of power, political power, and then it says politics is from the Latin and Greek roots as police. Literally, politics is maneuvering to acquire privilege of using the police. It's a very interesting book that talks about our Constitution, and it talks in there about the Liberty Bell, of what you're familiar with what's on the Liberty Bill.
Now, Jim, can you? What's the name of the book again?
The book is Whatever Happened to Justice.
Okay.
By Richard J. Mayberry.
Okay, last name Mayberry. Okay, go ahead, Rob.
Yes. And
Jim, my friend Joe Balliet.
Jim.
To Justice.
Okay, Jim.
Very interesting book.
Okay.
Thanks for your call, Jim.
Thanks, appreciate that. So go ahead, Rob.
I was going to say my friend, former State Senator Joe Balliet of Bozeman, had a different definition for politics. He would say the word politics comes from two Greek words, poly, meaning many, and ticks, meaning blood-sucking insects.
It's a good line, that's for sure. I wanted to talk to you a little bit. You were talking about the ability of a legislative body to kind of, at least in the case of Arizona, to set up an independent body that would make decisions for the legislature. And this is something that a lot of us are concerned with, especially after last week's past Wednesday's, I guess it was, FCC decision. A lot of people are wondering, why does a body that we never voted for have the ability to make blanket changes to the laws that we all have to live under, even if those laws would be in opposition to what the legislature itself would actually vote for? And people are wondering, how did it get to this point? Does the legislature even have the ability to give this, valuable public trust ability to a bureaucracy?
Tell you what, Rob, hang on to that. I'm sorry, wait a little bit long in the last break. So we're going to come right back and have Rob answer that question. We have two lines open, 1-800-568-5309 or 721-1290. We'll be right back. Hey, we're back on Talkback. 721-1290 is the number. Now, John just asked a question of Rob Natelson. He's of course, the Senior Fellow in Constitutional Jurisprudence from the Independence Institute there in Denver. And what about all these boards and agencies that are constantly throwing rules out there that have the effect of law, Rob? What's the deal with that?
Okay, well, let's divide this into two categories,
okay.
The state and the federal, okay?
All right.
The issue in the case now before the Supreme Court is whether the term legislature in a particular part of the Constitution means only the legislative body, that only the legislative body can divide the state into congressional districts, or does it mean the legislative power in the state? You've got parts of the Constitution it means one thing, in other parts of the Constitution it means another. What does it mean in this instance? If it means the general legislative power of the state, well, what's the ultimate legislative power of the state? The answer is the people. And in Arizona, as in Montana, it was the people who voted in a referendum to set up this commission. The people actually designated this commission as kind of a mini legislature for this one purpose, that is to say, for reapportionment purposes. So if the people were right about doing that on the constitutional issue, no real difficulty as far as it being an independent commission. The people itself set it up. When, however, you move to the federal government, and you've got commissions that were not set up by the people, what was set up by the people was Congress. And when the people set up Congress in the Constitution, they said all legislative power shall be vested in a Congress. Okay?
Okay.
And so there is a real constitutional dispute about the extent to which Congress can take part of its power and hand it over to agencies like the Federal Communications Commission. Now, the U.S. Supreme Court, including Justice Scalia, who's usually identified as a conservative, they've been very deferential to Congress and allowed Congress to delegate large swaths of power to these administrative agencies. But many people who study the Constitution, myself included, have some real doubts as to whether that really is consistent with the spirit of the Constitution.
Can I throw my lowbrow, just John reading things, kind of commentary to you and see if you agree with it? It seems to me it's a breach of the legislative and executive duties because, I mean, most of these legislative bodies, for example, the EPA or for example, the FCC.
You mean the regulatory bodies?
Yeah, they are charged and tasked with enforcing the law. And then the president has the ability, as he's shown over and over again, to basically force his will through these agencies and circumvent the legislature altogether. And it seems to me it breaks down, some of the checks and balances that the Constitution was laid out to kind of provide for.
Well, the way it's handled in the cases is they'll say Congress may not delegate the legislative power to these agencies, but it may delegate or may provide for standards under which the executive power is executed. So what Congress does is it passes a bill with very broad language and then creates these agencies in the executive branch and then tells them to enforce them within the very broad standards. I think that's okay to a certain extent. I mean, it's inherent in the executive power to exercise a certain amount of discretion. The difficulty occurs when Congress passes bills that establish standards that are extremely wide and extremely vague, like, regulate communications impressed with a public interest. Very broad sort of language, essentially handing over large areas of discretion to these executive agencies. I've got a real problem with that.
Okay, let's get to the phones, and Paul is up first. Paul, you're on with Rob Natelson. Go ahead.
Hello, Rob.
Hi.
I got a question about Article 4, Section 4.
Yes.
Just for your audience, the United States shall guarantee to every state in this union a Republican form of government.
Shall guarantee, you mean?
But the word guarantee is in there. That means absolutely. Right?
Okay.
Could you explain that to me a little bit, how this is going in relation to the tribes taking some jurisdiction over the rest of the people in the states?
Okay. That clause is called, and this probably won't surprise you, it's called the Guarantee Clause. I've actually written on it, and you can find my material on it at constitution.i2i.org.
Thanks for your call, Paul.
Yeah. The reason it was put in the Constitution was because the founders did not want any of the states to become monarchies or dictatorships. They had looked at history, in particular Greek history, and in Greek history there had been various confederations or leagues, and some of them were republican and some of them were monarchical, and the monarchs, the kings, would try to take over the league. So they wanted to make sure that no state became a monarchy or a dictatorship. So they put that provision in the Constitution, which requires every state to have a Republican form of government. And what a Republican form of government means basically is the state has to follow the rule of law, it can't have a king, and the government has to be ultimately responsible to the people. It doesn't have to be wholly representative, as some people claim, but it has to be ultimately responsible to the people. If it's a monarchy or a dictatorship, it's not Republican.
Now, how does that mesh with, for example, the caller? I believe he was talking about the Water Rights Compact here in the state of Montana, the CSKT Compact. Mm-hmm. But what about states where we do have basically you have tribes having control of areas of the state, things like that.
Right.
And at what point do treaties trump that kind of that authority?
Okay. The answer is treaties do trump that. You're moving into an area of constitutional law involving the tribes. The original understanding was that that the Senate and the President would make treaties with the Indian tribes, and the Indian tribes would either hold on to or be granted certain governing rights under those treaties. In the 1870s, what happened was that Congress passed a resolution which said we're not going to deal with by treaty anymore. We Congress are going to deal with the tribes directly. And Congress assumed to take over total control of Indian relations. I don't think that's constitutional. I've written on that subject as well. But a lot of what you see in terms of the tribes exercising power doesn't come from treaties, as it should. It comes from congressional laws like the Indian Child Welfare Act.
Okay. I was going to say we're up against our final 1 minute break. We also have a caller, Rob Natelson. He'll continue that thought when we come back after this 1 minute timeout. The final few minutes of Talk Back underway. Rob Natelson joining us as he does once a month from the Independence Institute. Now, I interrupted your thoughts, so if you want to go ahead and finish up, Rob, I'm sorry.
No, that's fine. Basically, much of what you see in the area of Indian jurisdiction, Indian law, is because Congress has taken over the field and Congress has made certain decisions. And as I said, that's not the way it was supposed to work, but that's what's developed.
All right, let's get Jim on the line. Jim, thanks for holding. You're on with Rob Natelson. Go ahead.
Good morning. Yeah, my question is concerning executive orders. Executive orders, he ordered private industry to stop manufacturing certain products, e.i. electricity. The next step, I'm assuming, is going to be his executive order is going to tell the private citizen that he must give up a product. What you kind of touched on it there in a previous caller, but what gives the president that kind of power where he can sign a piece of paper and tell industry to stop making a product, or tell Joe Blow citizen that he's got to stop using a product?
Right. Thanks. Like the incandescent light bulb, Rob.
Right. Well, I don't think the president really has that power. I mean, the president is... Okay, let's back up a second. Some executive orders are fine. I mean, the president is given the job to take care that the laws be faithfully executed. So, obviously, he's got to tell people what to do to enforce the law. So if he's issuing that kind of executive order, that's fine. If he's running foreign affairs through the State Department and he issues an executive order, that's fine, too. Other executive orders sometimes have been issued really without any authority at all, like President Truman's order to take over the steel mills back in the Korean War. And the Supreme Court struck him down, struck the order down, slapped the president down for that. But then there are other executive orders where Congress has either apparently or actually granted the president power to act. You know, Congress may say something like, if in the president's judgment such and such is necessary for the national welfare, then the president may issue an order to that effect. I think my view of that is the same as my view of administrative agencies. I think that the statutes have gone much too far in that direction. And then there are circumstances where the president really doesn't have authority under the statute. He stretches the statute to try to justify the order, and that you wind up in court. Difficulty is that the court actions take a long time, and a lot of people lose a lot of money and a lot of their lifetime dealing with unconstitutional action by the president. This is one area where some people have called for a constitutional amendment to clarify when the president may or may not issue such executive orders. It also points out the importance of electing presidents who truly respect the Constitution, who don't merely pretend that they do.
We got a couple Facebook posts here. Let me go through them.
You have about 3 minutes.
First up, this is from Doc. He says, Rob, why are so many conservatives, and he puts that in quotes, dug in against an Article 5 convention to amend? They drive me crazy with their just say no to a con mantra. Are they really cowed by the fear of libs taking over?
You know, I can't crawl inside people's minds as to tell you why they take a position that they take. All I can say is that the whole con mantra was first publicized widely in the 1960s and 1970s by people who wanted to block some conservative amendments, who wanted to protect decisions by the Supreme Court, like Roe versus Wade, who wanted to protect an overreaching Congress. And so they largely invented, or they partly invented and partly simply disseminated these claims, and they're nonsense. There are some groups out there who have, who make money off spreading these claims or scaring their membership. Give us money, please. Send us your contribution, or we're going to have a con. I suppose that's probably an element to it, but partly, the truth has only been recaptured the last few years, and sometimes it takes a while for facts that have been discovered or rediscovered to sink in. It's going to take a while, I think, for some people to accept the notion that we really can safely have an Article 5 Amendments Convention.
That's my understanding, that a lot of conservatives that tie themselves back to, like, for example, the John Birch Society, find themselves on that side of the playing field as well.
All they're doing, John, is they're turning over control of the amendment process to Congress. That's what they're doing.
Yeah.
Because if the people can't have a convention for proposing amendments to propose their own amendments, then the only group that can ever propose amendments is Congress.
Okay.
And so you're essentially saying you're giving Congress an absolute veto. That's not what the founders intended, and that's why the founders put the Article 5 Convention into the Constitution, to provide a way in which we, the people, acting through our state legislatures, can wire around Congress.
Okay, we have less than a minute,
Yeah.
Rob. If we could kind of tie up here, give people address for your website so they can go check out your work.
The third edition of my book is out, The Original Constitution, What It Actually Said and Meant, and you can get that at Amazon. Also, website is constitution.i2i.org, constitution. The letter I, the number 2, the letter I.org, and there's all sorts of stuff to read there.
All right, perfect.
Rob, always a pleasure. We look forward to talking with you the first Tuesday in April.
Thanks, guys.
All right.
Appreciate it.
Thank you, Rob.
Bye-bye.
All right, Rob Natelson there, ladies and gentlemen. And again, that's the Independence Institute in Denver, Colorado. Tomorrow,
Taxman Walt Caro's on with us.
there you go. I just got my taxes done with Walt, and he is now my new personal hero.
Oh, really?
Yes.
So I'm off the list, huh?
Yes.
Dang.
Sorry, you're out. Just leave your hero badge. And
What about the underwear? Do I have to take the hero underwear off too?
Please keep it.
Okay.
That's non-returnable item. Anyway, I want to say thank you to everybody who called today, and again, thanks to Rob Natelson. You guys enjoy this beautiful day, and we're expecting spring to arrive in the next couple of days, so get through it. Have a great day.